Washington recently signed into law Senate Bill 5375, which amends the mandatory reporter law in Washington to include members of the clergy as mandatory reporters. This means that if a priest or any other member of the clergy learns or has reason to know of child abuse going on, they must report it to authorities. Now, this may seem like a reasonable law on its face, but for Catholics, this signals a sharp turn against the free exercise of religion. So, in Catholicism, we have reconciliation, which is where we have to go to a priest to confess our sins, and then the belief is that God acts through the priest to forgive our sins. Priests are bound by what is known as the seal of the confessional, which essentially swears them to absolute secrecy regarding anything told to them in the confessional. And so this law forces priests to make a decision: obey the law of the state or obey the law of God. And I should mention that if a priest breaks the seal of confession, then they may be subject to excommunication from the Catholic Church. Now, Trump's Department of Justice, led by Pam Bondi, has opened an investigation into this Washington law, claiming that it might violate the free exercise of religion. Now, to many, this may seem like a pretty straightforward case for the DOJ, but a deeper understanding of how the Supreme Court actually analyzes these free exercise cases reveals that it may not be as straightforward as it seems. So when I was in law school, I took a class on the religion clauses in the Constitution. For this case, though, we really only need to discuss two main cases, and that these two cases do a pretty good job describing how the Supreme Court analyzes these cases. Then later I'll bring in a third to kind of highlight an argument that the DOJ may attempt to make. The first case comes from 1990. It's called Employment Division versus Smith. Many people maybe have heard of this case before. You may know it as the peyote case. An Oregon law prevented unemployment benefits to anybody that was using drugs. And a Native American was denied benefits after it's discovered that he used peyote, which in his faith had sacramental significance. And so the Supreme Court, when they looked at this case, it was actually Justice Scalia who wrote the majority opinion of this case, who is kind of a conservative hero on the court. This case, though, a lot of people, especially on the right, are not big fans of, because he ruled that the Oregon law was not constitutional, even as applied to the Native American. He ruled that neutral, generally applicable laws that incidentally affect religious practice will be upheld as constitutional. So that brings us to our second case, which is just 3 years after that, 1993, Church of Lukumi Babalu I versus the city of Hialeah in Florida. So the city of Hialeah had passed an ordinance that banned the ritualistic slaughter of animals. And they did this because the Santeria religion, which is kind of a Caribbean, Afro-Caribbean religion, they were going to build a temple in the city. And the city didn't like that, so they passed this law that banned a specific practice of this religion. They engaged in ritualistic slaughter of animals. And so the Supreme Court looked at this and said, hey, there's evidence that the city is targeting this religion specifically, and so we're going to analyze this ordinance under strict scrutiny. And under strict scrutiny, the law must be narrowly tailored to serve a compelling government interest, and the law must be the least restrictive means of achieving that interest. And so the court looked at this and they decided that the ordinance did not pass strict scrutiny. They banned the specific practice of the Santeria religion, but they allowed killing animals for food, for hunting, and even other religious practices such as kosher killings and halal killings. And so the court looked at this and said, hey, this law is not narrowly tailored to achieve your government interest, which they said was like public health or something like that. And it was not the least restrictive means of attaining public health. They could have passed the law about how to discard of dead animals or something like that, which would have been a better way of achieving their stated governmental interest. And so essentially with those two cases, we were left with neutral, generally applicable laws are constitutional. But if there is evidence of religious targeting, then the law must pass a stricter test called strict scrutiny. Now, Congress did not like the ruling in Smith, and so they passed the Religious Freedom Restoration Act in the 90s. And this basically said that any case of free exercise has to be analyzed under the strict scrutiny test that the court used in the Hialeah case. Now, the Supreme Court later ruled that the Religious Freedom Restoration Act, which I'll probably refer to from now on as RFRA, was unconstitutional as applied to the states, meaning that federal laws have to pass strict scrutiny, while laws by the states are still governed by the standard set in Smith, that neutral, generally applicable laws will be upheld as constitutional. And so that brings us to Washington's law. I read through the law, and it really stands out. This law is written to avoid strict scrutiny. So the first section of this law is basically a definitions section. It's common in laws if you start looking through them. The first section will just be a giant list of definitions. And in their definition of members of the clergy, it includes all faith practices, any denomination you could think of, Christian, non-Christian, everybody. And it includes a all-encompassing term, all other people who may be considered members of the clergy. So everybody is included under this law, which makes it generally applicable. And that presents a problem for the Department of Justice if they were to bring this case to court. The second section of this bill amends the previous mandatory reporter law to include members of the clergy, and they do not include an exemption for Catholic priests or any other faiths, which, again, generally applicable to everybody. But the Department of Justice, I believe, will make an argument that this third section of the law is what violates the Constitution. So the third section of the law says that if there anybody that works under you is committing child abuse and you have reason to know, you have to report it to authorities. But it includes exceptions to the rule for privileged communications, which is defined in another Washington law. And this other Washington law defines privileged communications as between, communications between spouses or between an attorney and a client. And a third privileged communication is between clergy and the penitent. But in Washington Bill 5375, which just passed, it specifically excludes clergy and penitents from the list of exceptions. And so I think this may open an angle for the Department of Justice to come in and say, hey, this law is not neutral. It's not generally applicable because you specifically exclude clergy members when you have these other exceptions there. And there is precedent for the DOJ to make this argument. In 2021 case, Fulton versus City of Philadelphia. City of Philadelphia passed a law that basically said that if you operate an adoption agency in the city, you must serve same-sex couples. So Catholic Social Services was not able to operate within the city, and they sued violation of free exercise. The court came down on behalf of Catholic Social Services unanimously. The issue with the law is that it provided exceptions at the sole discretion of the city commissioner. And so he could provide exceptions for some people and not others. And the Supreme Court basically said, hey, if you're going to have a government official make individual exceptions, you have to include religious exceptions in there. But I think a key difference between this Washington law and that Fulton v. City of Philadelphia case is that in this Washington law, there are no individual exceptions allowed. There's just blanket exceptions that are written into the law. And so you don't have a random government official deciding one by one who's accepted and who's not, And so that puts this Washington case outside the scope of Fulton v. City of Philadelphia. And so what's the Supreme Court going to do in this case? One option would be to expand Fulton v. City of Philadelphia and say, hey, if you include any exceptions, you must include a religious exemption. That's possible, but the concurring opinions from that Fulton v. City of Philadelphia case show that there may be a move in the Supreme Court to overturn Smith and get rid of this neutral, generally applicable law. So Justices Alito, Thomas, and Gorsuch all joined in a concurring opinion in that Fulton v. City of Philadelphia case. And in this concurring opinion, they ripped apart Smith. So one of the most notable things about their concurring opinion was that they went through specific instances throughout history where Smith would uphold a law that very clearly violates religious freedom. So I'll give you a couple examples. One of them was prohibition in the 1920s. the prohibition law specifically excluded wine for Catholic Mass. And under Smith, that law would be upheld as neutral and generally applicable, but it would violate a very key tenet of the Catholic faith. Another example they gave, there are some European countries that have a law that animals must be rendered unconscious before you slaughter them. But that would go against kosher and halal killings. And so if a state passed that, that would be upheld under Smith as neutral and generally applicable, but it violates a very key tenet of the Jewish and Muslim faith. Another concurring opinion from Fulton v. City of Philadelphia was written by Justice Barrett, and Justice Kavanaugh and liberal appointed Justice Breyer joined in, which is important here because I'm sure if Smith gets overturned, there will be liberals out there saying that the court, this is just another example of how the court's biased. But we have precedent from this Fulton v. City of Philadelphia case that even liberal justices are not totally on board with Smith. Now, this concurring opinion, they did not go as far as Alito, Thomas, and Gorsuch. They signaled more caution in overturning Smith, but they recognized that problems exist with Smith. What they didn't want to do is get rid of Smith and go back to RFRA, the Religious Freedom Restoration Act, which said that any case of free exercise has to be upheld under strict scrutiny. They did not want to go that far, but they did signal an openness to overturning Smith and putting something new in place. And so I think that's what will end up happening in this case, because you already have 3 justices on the court that want to overturn Smith and go basically to RFRA. And you have 2 justices that want to overturn Smith, but they don't really know what the new framework is going to be. So I think that we will get an overturning of Smith, but what the new framework's going to be, I'm not sure. You may have a plurality opinion that overturns Smith, but 3 different ideas on what's next. And in that case, it'll be the narrowest opinion, basically, will be the ruling opinion. That would be my guess for what happens. But I'm not going to try to guess what the new standard will be. But I do believe that Smith will be overturned and that the seal of the confessional in the Catholic faith will be upheld under the United States Constitution, which it should be.